Hello friends, welcome back to my channel. So today we'll be talking about misrepresentation. What is a misrepresentation in an immigration application? It can be any application. It can be a student visa application, it can be a visitor visa application, it can be a PR application, work permit application, any application. What can be the misrepresentation? What is a misrepresentation in an immigration context? So anything that you hide in the application or anything that you lie about in an application, if it is in your knowledge, if it is in your control to know, and you still give them wrong information, that is misrepresentation. So let's say if it is you are married and you mention your marital status as single, that is misrepresentation. Let's say if you're single and if you're cite your marital status as married, that is misrepresentation. Let's say you did not declare about your education. Some people choose that. Some people in study permit application, there is a common guidance given by a lot of people. Okay, hide this detail, hide this information, show this detail, show this experience that you don't have. All these things are misrepresentation. So you are basically giving them, whenever you are giving them false information, that is misrepresentation. And that can lead you to inadmissibility for 5 years. So that means you can be banned for 5 years from Canada. If you are in Canada, if you are found to be inadmissible, you can be removed from the country, or if you are outside Canada and if you have submitted this application and you are found to be inadmissible, that means there is a 5 years inadmissibility on you, then technically you cannot submit any other application to Canada, any other application. So let's just say that some people do that. I mean, some people hide their previous visa rejections in USA or in any other country. Let's just say that you have been refused visa of USA, you have been refused visa of Australia. You must cite this information. You must cite this information in any Canadian application. If not, then the information sharing of these two countries, they will figure out that you had a rejection, you had a prior rejection that you did not mention in this application, and because of that you will most likely receive a procedural fairness letter, and on the basis of that procedural fairness letter, if you don't answer that procedural fairness properly, in that case then you will be found inadmissible to Canada for a period of 5 years. Now, some people even give them wrong information about experience, which is not good. Some people, they have not done work at particular place and then they still claim it in their visa application. There is a risk of inadmissibility. There is a risk of you are lying to the immigration authorities. So in that case, you are subject to inadmissibility. And for the next 5 years, you will not be able to submit any kind of application to Canada. And there are exceptional circumstances in which you can, but it depends on facts and depends on the scenario. But generally, you cannot submit any kind of application to Canada. The other thing, now the common thing, the next question I think the people will have is, what is the solution? It depends. It depends on the facts of the case. It depends on what kind of procedural fairness you've been offered or not offered. If you have not been offered any kind of procedural fairness, Procedural fairness, that means your input. So basically, let's just say that if you have lied to the Immigration Canada about your US rejection, and you get a letter saying that, okay, we have found that you have lied in your application about your previous visa rejection, what do you have to say to that? So basically, they ask you for your explanation on what can be done next, or what is your take on that. So basically, you have to provide an explanation on why you forgot to mention, or why you intentionally did it, whatnot. It depends on the explanation that you have provided. It depends on the wordings of the procedural fairness letter. The solution to this is judicial review. You have to take this to the federal court, but only if there are merits in the case. I mean, you cannot take any random cases to the federal court. There has to be some sort of merits in the case. So, for example, sometimes the PF letter, the procedural fairness letter that is received in this application, is incomplete. Sometimes the response that you have given, it is not considered by the officer, and that may be the reason to appeal it to the federal court. But the only remedy in this situation, practically, is a judicial review. The other important thing to note here is that this inadmissibility extends to your family members. Not extended family members, but at least your immediate spouse. Your family member, let's just say that if you are found inadmissible, then under the Immigration and Refugee Protection Act of Canada, your spouse is also inadmissible. So that means that your spouse can not apply for any other kind of application because you are inadmissible to Canada. The solution to this is judicial review, but then it depends on case-to-case basis. It depends on the facts of the case. It depends on the responses that you have submitted in response to the PFL. But this is the only remedy that I see in this situation. Thank you for watching. Stay tuned for more videos. Thank you.